Mr. Speaker. I call the Honourable Rick Barker.
Firstly, Mr. Speaker, I would like to acknowledge the compliments paid to me by the Honourable Simon Power and say it is appreciated. It's very seldom do you have across the House acknowledgements of work. And could I say in that regard that this bill should be seen in the context of a range of bills to try and modernise and update the administration of justice in this country. When I first became the Minister for Courts, I was quite surprised at how antiquated the administration of justice was in New Zealand. It was complex, it was arcane, and things were done which were appropriate for 50, 60 years ago, but no longer appropriate in the modern time. For example, if a person had a debt to the High Court and had a debt to the District Court, two people had to go and serve the notice of debt, one for the High Court and one for the District Court. Well, as far as the person who owed the money was concerned, it was to the court and was to the state. But the state had a different perspective on it. This meant that there was a considerable amount of duplication. These circumstances arose, I think, principally because, not wishing to be cast aspersions on the efforts of my predecessors, but I think that there was an overdue emphasis on looking at justice as policy and public law rather than the administration of law. And I think that we should have spent a lot more time on it. Myself personally, I didn't see myself as having a great deal of expertise in public law, but I did see myself as an administrator. And so when I looked at the court system, I looked at them as an administrator would and said what needs to be done. And a great deal has been done, and I want to acknowledge the good work of cooperation with the Honourable Simon Power over, for example, the depositions, which are not touched with on this, but a very important piece of reform. And I know there's a substantial amount of other reform going on in addition to this legislation to improve the administration of justice. And I think this is an area in which all sides of the House should work cooperatively with and constructively to make sure that our justice system performs to the highest level it possibly can. There's a great deal of room for more improvements, and I hope to see many more courts and criminal matters bills and other justice bills come before this House to improve the administration of justice. We tend to spend this Parliament time on legislation which has a high public profile about offences and offending and so on, but we spend little time on the administration of justice. This is one such bill, and as I repeat myself, I hope that we see many more of them. The bill covers a lot of acts, as the Honourable Simon Power has read out. I was quite surprised when I came into contact with this work just how many agencies were involved. It is a vast network, and all have to be actively engaged with in the way in which New Zealand does its legislative work, which I think is very good. There is a high degree of consultation with the local authorities, with all of the other agencies, police and so on, to make sure that the legislation works and works well. And there was a clear determination to make sure that it worked well. And it was because our systems weren't working. Very often we had in the courts young people who were confronted with $20, $30, $40, $50, even $70,000 worth of outstanding fines, and the system seemed to be incapable of dealing with it. It's a little bit like the old saying of Lord Maynard Keynes: if you owe the bank $100, you've got the problem. If you owe the bank $1 million, the bank's got the problem. And so it was with the justice system. If young people had a small amount, then the young person had the problem. But when they were at $70,000, the system of justice was in the spotlight. And I think that is a significant problem. I regret to say that this piece of legislation doesn't do as much as I think we could have done in this area. I think there are two other interventions we could have made, and I hope that they come later. The first is to have an early intervention on young people when their fines get to a certain amount, say $2,000 or $3,000, and case manage those. There's no point in us trying to case manage this when the young person is before the court with $70,000 worth of fines. I think that's an area that we can get involved in. But the area that we have taken a strong lead on in this is for outstanding fines. And I want to repeat what I said in the committee stage of this bill. One of the things that drove me on this was a letter from a constituent, a person who was known to me, whose mother had been involved in a dreadful accident. And at the court hearing, it came to his attention that the young man driving the car had approximately $40,000 of outstanding fines and a range of other prior convictions. And the letter went on to say, did the system not understand or appreciate that this young man was a menace on the road and was likely to cause an accident? And the accident occurred to his mother, who was in hospital under considerable pain. Well, there could only be one answer to that question. We should have known and we should have taken action. But we didn't, and the system needed to change. People needed to be held to account for their fines. The point was this young person could drive, incur a fine, not pay it with impunity. And because they could avoid their fines with impunity, they saw the justice system as lacking teeth, lacking enforcement, and lacking credibility. And I thought it was time for us to do something. Now, there are three things which are going to happen as a consequence of this information. The first is a person's licence is going to be under threat if they do not pay their fines. The legislation provides for a driver licence stop order, which will say to the young person, if you have not taken responsibility for your fines, your licence will go. The second thing which is going to happen is that we're going to deal with a problem that was brought to my attention by officials, that some young people were getting high-speed cars, expensive cars, driving very badly, incurring huge numbers of fines, and when the car was seized and sold, the finance company got all of their money for the car, but there was nothing left to pay the fines. The young person having the seized car would immediately turn up to the dealer again, finance themselves with another car, and carry on driving down the road. Now, the dealer knew the circumstance of this young person's driving and knew what was going on, but there was no disincentive for them to not finance the vehicle. Well, there is now going to be a strong disincentive. If the young person has a substantial amount of money owing in fines and reparation for their bad driving, then if the dealer sells them a car and the car is impounded, the dealer is now told that the fines and the reparations outstanding will be taken out of the proceeds of that vehicle first, and only if there's something left over will they get their money out. Now, this is going to be a strong disincentive to financing bad drivers back into more vehicles, and I applaud that. There were some concerns about this from a privacy point of view, but I'm happy to report the Privacy Commissioner spoke to the Select Committee and was very happy with the arrangements we've had. The third element of this is that people were racking up large amounts of fines and they were having no effect on their particular financial position, didn't affect their credit. They would therefore be paying off, they had multiple debts, they would pay off the debts that they owed to the private sector and not pay the debts that they owed to the Crown, would not pay the reparation. Because if they paid off their debts in reparation ahead of the private sector then, and left the private sector debts, then those would impact upon their creditworthiness. But if they paid off their private sector debt and didn't pay off the debt to the Crown, then it would appear to all the world that they had a good debt record and it would have a positive credit rating. Now, I thought this was wrong. This bill changes this. So if a person has a debt to the Crown for fines and reparation, it will be in the public record and it will affect them. So when they go to get a credit card, when they go to get finance of any sort, a finance company will see that this person has 5, 10, 20, 30, 40, whatever thousands of dollars outstanding is, and will know the sort of person they are and will know the liability. Now, this will put extra pressure on those people to pay. This is a good bill. It contains many things that are going to improve the processes of collecting debts, improve the processes of putting attachment orders on people for debts. It'll simplify the system across the board. It'll mean that one official from the Ministry of Justice will be able to serve debts from multiple courts and multiple jurisdictions. All of this is good stuff. There is nothing down in this piece of legislation at all. The last point that I want to come to, and this is, I think, a very important one, is the ability to re-sentence. I think this is very important because many young people have gone before the court and promised to pay reparation and have had that's just been taken into account when they've been sentenced, and they have not. And they have laughed at the courts because of this. This change here will say to them, if you do not pick up on the promise you made, you will come back to court and we will hold you to account and be able to throw the book at you. This is a very good provision. Thank you.
I call the honourable